In the case of the United States Supreme Court, New York Times Company versus Sullivan. The parties in this case involve a writer of the New York Times Company, a newspaper company, and L.B. Sullivan, a Montgomery, Alabama Commissioner of Public Affairs, whose duties include supervision of the police department, the fire department, and the Department of Cemetery. The facts that led to the dispute came from the New York Times publishing a full-page ad and Sullivan claiming that his name and reputation had been defamed when the ad was published. The ad summed up actions supposedly done by the Montgomery, Alabama Police Department. The way that the ad was written, it could be construed that Sullivan was the they, as noted in the ad, speaking of the misconduct of the Montgomery Police Department. For the elements of defamation, the plaintiff had to prove that actual malice had taken place, proving that the statement was made with knowledge of its falsity or with reckless disregard of whether the statement was true or false. In the decision of the case, the United States Supreme Court decided in favor of L.B. Sullivan, and he was awarded $500,000. The statements were documented as being libelous per se, and malice was presumed. There was reckless disregard to whether or not the said written actions were false or true. It was decided that it could be implied that the word they could mean Sullivan himself, a commissioner of the Montgomery Police Department, had given orders to the police for said actions. In the case of Elmer Gertz versus Robert Welch Incorporated, the parties involved in this case are the petitioner Elmer Gertz, a lawyer, and Robert Welch Incorporated, a writer for the American Opinion. It was decided that Elmer Gertz was a private person because there was no evidence of general fame or notoriety in the community. The alleged defamatory statements accused Gertz of being a communist fronter and Leninist because he represented clients who sued law enforcement officers. In the article, it also stated that Gertz had been an officer of the National Lawyers Guild, described as a communist organization that planned the communist attack of the Chicago police during the 1968 Democratic Convention. As to the confirmation of accuracy, the magazine editor admitted in an affidavit filed that he had made no independent effort to verify the claims in the article and that he had relied on the author's reputation and previous works. The allegations against Gertz in the magazine were not facts, and because the article was based on one person's opinion, this would have ruined his reputation as a lawyer and as an influence within his community. What would I have done differently than Welch? I would not have printed my opinion of someone. I would not have labeled Gertz as something that I had no facts on. I would not have judged Gert's character without having all of the evidence needed to back up my claims that I intended to publish. In Michigan, defamation laws are as follows: saying or writing a false and defamatory statement concerning the plaintiff of a case, conveying to an unprivileged publication to a third party, being at fault or at least to negligence on the part of the publisher, being either actionable of the statement without regard to special harm, defamation per se, or being the existence of actual harm caused by the publication. What have I learned from these case studies? I can relate what I have learned from the Sullivan and Gertz cases, and I can apply it to my future work in the communications industry. I have learned to choose my words wisely. I will not write slanderous articles. I will not misrepresent a person's character for the benefit of a story. For the sake of my reputation, I will make sure that the stories I write concerning someone's character are justified with evidence. Being a good journalist is more than just having a good story, but also having a good reputation that will gain just as much notoriety. This is Cynthia Gladden from CynthiaGladden.com.